Yes, Mr. De Cruz.
Thank you, my lord. My lords, at the risk of trying to teach my grandmothers how to suck eggs, I think it is important to identify some core appellate points that are relevant to the way that we approach this appeal, because in my submission they have been elided in the arguments this morning, which have amounted in substance to a rehearing. The grounds of appeal before you fall into two categories, I respectfully submit. It is said in relation to Mr. Justice Knowles's judgments, both as regards the set-aside application and the relief application, that he alternatively failed to take into account relevant matters or took into account irrelevant factors. That's the first category. And then, and we say this is really what the appeal amounts to, that if he did take into account relevant matters, he failed to give them sufficient weight. Now, the reason it's important to distinguish between those two categories is that the former involves an error of law, the latter is discretionary, and as to the latter, this court's role is only to police, using the phrase in Azam, the very wide parameter afforded to Mr. Justice Knowles, and to recognise that as long as he took into account all the relevant factors, it is a rare thing to conclude that he exercised his discretion beyond the broad parameters available to him. And it's in Azam, in fact, that Mr. Justice Saini made the point that when one is dealing with a discretionary issue, it's really rarely appropriate, if at all, to engage in a re-argument of the points below. So the other core appellate point that is particularly important to bear in mind here is that unless demonstrated to the contrary, Mr. Justice Knowles is assumed to have known what points to take into account and what not to take into account, particularly where that applies to the tritest of principles of law that we are dealing with. And it is also important to avoid a narrow textual analysis of his judgment as a pretext for disturbing the exercise of his discretion, particularly where, as has occurred, that textual analysis not just ignores the arguments that were put before him orally and in skeleton, but actually ignores what he himself says in preceding and subsequent paragraphs, as I will explain to you. In determining whether or not Mr. Justice Knowles, for example, provided good reasons for his approach, one needs to take a sensible course and look at his judgment as a whole, identify what points he addressed in that judgment, and the true meaning of his conclusions in that context. And that is not what has occurred, for reasons I'll bring you to in a moment. So what, in my submission, has actually occurred is that Mr. Justice Knowles, and we can see this from his judgments, has addressed all the proper issues. He's taken all of them into account. And one is dealing here with a quintessential discretionary exercise of his, addendum stage 3, in both the set-aside application and the relief application, on a case management issue. And there is a further point of context that your lordships, I'd ask your lordships to take into account in assessing both judgments, and that is this. On the day itself, at the hearing before Mr. Justice Knowles, the judge was being asked to deal with 4 applications, all in one day, and he provided an extempore judgment in relation to all 4 applications. It is hardly surprising, therefore, if he did not cite all of the parties' arguments, or all of the relevant rules, and all of the relevant cases in that extempore judgment. And so your lordships should be very, very cautious, particularly in that context, in drawing an inference that he did not take into account trite points simply because they weren't mentioned. Now, subject to your lordship's preference, turning to the actual grounds of appeal, I was proposing to deal first with the appeals in relation to the second defendant before coming to the appeal in relation to the first defendant. Happy to take it the other way around if that would be of assistance. But this is the order in which we took it before Mr. Justice Knowles and he thought relevant.
All right.
Thank you. So, in relation to Michelle Saab, and I should also say that what I'm going to do, because this is the correct appellate approach, is to address the points raised in the grounds of appeal. Leadingway has received permission to appeal in respect of specific grounds, and your lordship's function is to assess whether in relation to any or all of those grounds, or the extent to which any of those grounds are made out, and not to entertain new arguments that are put before you today. Now, the first of those grounds is 3A, and your lordships will find that at, I should ask actually, would your lordships be assisted if I gave you the tab references as well as the page references for the bundles, or?
Yes.
Yes, 1.1 and paragraph, page 14.3. So what's being said here, the complaint here, is that the judge supposedly failed to take into account the proportionality of the Foxton sanction, and it is said that was not an issue as it had been considered by the court and agreed by the parties. So in essence, what's been said here is Mr. Justice Knowles took into account an irrelevant factor. That's what stripped down, that's what the complaint is. And that's wrong because, first of all, if one looks at, and this is something that you should have your thumb in if you would, the judgment is at tab 10. And if one looks at paragraph 9 of tab 10, that's where Mr. Justice Knowles says, if I look at all the circumstances of the present case, I cannot accept that they lead to a conclusion that a just approach is to refuse relief from sanctions. And so what he was doing there is not addressing the proportionality of Mr. Justice Foxton's order, but the proportionality of enforcing that order. And those are two very separate issues.
Sorry, you'll have to explain what you've just said because it doesn't make sense to me.
So, when the order is, when an unless order is made, as Lord Justice Moore-Bick identified in Marquand Shipping, the judge being asked to make that order, and we say in a disputed context, has to consider whether the sanction to be put, that he's being asked to put in the order, the judge being asked to put in the order, is proportionate at that stage, at the date on which the order is made, being imposed. That's one issue. There is a separate point which arises in a relief from sanctions stage as to whether it is then, at that stage, proportionate to enforce the terms of the unless order. And we can see that as being two separate stages from what Lord Justice Moore-Bick himself says in Marquand Shipping. You can find it at tab 36 and page 80. You can find it at tab 5, paragraph 36 at page 85. We'll take that up quickly.
Which tab?
Tab 5, my lord.
5.
Page 85, paragraph 36. It appears in a section which you'll briefly see at the top of, just before paragraph 28. The analysis here is about the effect of CPR Part 3 in brief. That's page 82. And at paragraph 36, Lord Justice Morbick makes the following points. Before making conditional orders, particularly orders for striking out of statements of case and the dismissal of claims or counterclaims, the judge should consider carefully whether the sanction being imposed, i.e. at the date that the order is being made, is appropriate in all the circumstances of the case. Pause there. He was addressing that point in the case of a disputed application on an unless order. But he goes on to say, of course, it is impossible to foresee the nature and the effect of every possible breach, and the party in default can always apply for relief. But a conditional order striking out a statement of case or dismissing a claim is one of the most powerful weapons in the court's case management armory, should not be deployed unless its consequences can be justified. So in that second part of paragraph 36, what we submit is clear. Lord Justice Morbick is recognising is that once the order is made, once the judge, having made the order, has assessed, yes, it's proportionate to make it at the date of the order, events will always move on in some form or another to a point where, in the case of a breach of the order, the breach occurs. It's impossible to analyse at the date that the order is made how severe that breach is and whether it merits relief from sanctions. And that is a separate question that then comes to be analysed at the relief from sanction stage. So that was the issue before Mr. Justice Knowles. What is put against us is that, or rather against Mr. Justice Knowles, is that he was analysing the proportionality of the Foxton order itself, when in fact what he was doing, quite correctly, per this paragraph, was considering the order having been made, let me consider the circumstances in which the breach occurred and the nature of that breach, and that is a separate point. So the factual foundation of ground 3A that Mr. Justice Knowles took into account an irrelevant factor is, we respectfully submit, simply wrong. He took into account the proportionality of enforcing the Foxton order, which he was entitled to do.
I may have misunderstood, but I didn't understand his being able to advance that argument before us.
Well, it's the way in which ground 3A is worded.
Yes.
And it's worded
This is a pleading point. You're saying that this whole appeal is futile because that is to be taken as an appeal in effect from Mr. Justice Foxton's order, rather than an appeal from Mr. Justice Knowles's grant of relief from sanctions.
No, that's not quite the point I make, my lord. The point I make is this. Ground 3A introduces two criticisms of the judge. One, that he took into account an irrelevant factor, the proportionality of enforcement of Mr. Justice Foxton's order, and the second, that he failed to give proper weight to the fact that the order had been agreed.
Yes.
The first amounts to, would, if it was factually correct, amount to an error of law. The second is an issue of discretion. And it is important for your lordships to identify that we are in the territory of the second rather than the first, because your approach to Mr. Justice Knowles's judgment is entirely different. It's the generous ambit point. It is whether or not he strayed beyond the scope of reasonable decisions available to him.
You introduced this point by saying that it was this central point relating to the appeal from the giving relief against sanctions to the second dependent, that it's simply not open to her because it's been pleaded in this way. And I'm sorry, I just don't understand it. I think I made clear, I think, to Ms. Bingham that, speaking for myself, I don't think that a judge in approving a consent order between parties that nothing to do with children or protected parties or family cases or something, approving a consent order, that a judge is not required by Lord Justice Moore-Bick's judgment or otherwise, is not required to make a value judgment on whether an unless order is appropriate. The judge is perhaps required to check whether the order makes sense, doesn't have typos. There's the point about the date, which you'll no doubt come to. But the main point made in ground of appeal 3A is that in the relief against sanctions assessment, stage 3 of Denton, if you like, the fact that the parties had themselves agreed that this should be an appropriate sanction is very significant, and the judge failed to take account of it. At the moment, I don't see what the pleading point is.
Well, I think if we could move on to the substance of it, I think we're on the same territory in the sense that we are in discretionary territory as far as 3A is concerned. And as far as in terms of the fact that the order was made by consent, that was a point that was obvious to the judge by the very terms of the order itself. But I'll come to that in a moment. I'm proposing to come to that in context of ground 3B, where one talks about compliance. Because the issue is, I think, as your lordship has rightly focused on, ultimately, the issue is whether the judge got it right in terms of the way in which he exercised his discretion at stage 3. And that applies, in my submission, both to the position as regards Fareed, the first defendant, and as regards Michelle, the second defendant. That's what the battleground is here. And one has to take into account then, he is engaging in an evaluation of competing factors. Did he get it so far wrong that the Court of Appeal should interfere with that evaluation? That is the big point, in my view, in my submission as regards both appeals. Now, as part of that, we come, I think, logically to ground 3B, which is the importance of compliance with court rules, that principle. I call it the compliance principle. And here it said that the judge, again, failed to recognize the need to enforce compliance with court rules. And alternatively, it said that he ignored that point or afforded it insufficient weight. Now, the basis of that argument appears to be that the judge did not identify the compliance rules specifically in express terms in his judgment. But that argument, first of all, ignores the extempore nature of the judgment and therefore how the judgment is to be evaluated by your lordships, and the principle that the judge is assumed to have known that this was a trite factor for him to take into account. But more importantly, one can see from the judgment that he did, in fact, take it into account very clearly. And that is apparent by from paragraph 10 of the judgment. Again, we're back to core bundle, tab 10. This time, we look firstly at paragraph 4. you will see the approach that the judge took. As to the question of seriousness and significance, this is the case of an unless order. It's a case where the unless order was not followed by a previous breach, but does follow prior extensions. It does not cause a degree of disruption. Given that that an unless order was involved, the better approach is to treat this as a matter of seriousness or significance and thus proceed to the further stages. So the first point I make there is that it's apparent from the fact that the judge treated a one-day delay as serious and significant in the context of an unless order, that what he was focusing on there in reaching that seriousness finding was the importance of compliance with court orders. That is the only fair way of analysing his comments in paragraph 4. But that he had the principle firmly in mind is also apparent from the following. It was quoted verbatim, the compliance principle was quoted verbatim in paragraph 27 of our skeleton at first instance stage. For your lordship's reference, it's supplemental bundle, tab 7, page 34. It was also referred to in paragraph 59 of Leadingway's skeleton, reference, supplemental bundle, tab 8, page 69. I brought it to the judge's attention expressly at the outset of the hearing as well. And I'd like you just to have a quick look at that. Supplemental bundle, please, tab 14, page 90.
Sorry, could you give me the reference again?
Yes, my lord. Supplemental bundle, tab 14, page 90, 90. And could I direct your lordship's attention towards the bottom of section E, where I said this to his lordship. This is the very beginning of the hearing. Your lordship will be very, very familiar with it, I know. But it's important, I think, just to remind ourselves of the structure of this, which is that this is an application, that in an application such as Michelle's for relief from sanctions, the court will consider Rule 3.91. And I quoted it to him verbatim. All of the circumstances of the case so as to deal with it justly with the application, including the need for litigation to be conducted efficiently and at proportionate cost, and to enforce compliance with the rules of the practice direction. That was the very first point made. So to imagine that Mr. Justice Knowles forgot that point in his analysis, which is what is in effect being said, at least as part of the argument, is not right. It's not accurate. So again, we're talking about sufficient weight here. Sufficient weight about the compliance principle when it comes to stage 3. That's the reality of ground 3B.
Where does the judge deal with the point that this was an agreed order, so it was in the nature of a contract?
Well, as far as the contract point goes, my lord, we say that's simply wrong. It isn't a contract. There is no authority put before you, to the effect that where parties agree to a consent order, the legal effect of that is a contract.
Agree to an unless order.
To agree to an unless order.
Yes.
Yes. And if one,
It plainly is a contract.
no, it's an agreement.
It's one of the reasons why it's difficult to vary a consent order.
Lord, if we are using the word contract as I understand us to be using it in its technical term, in the sense of a binding agreement giving rights to private rights between the parties, that is enforceable. That, with respect, is not the correct analysis. The situation that arises when a consent order is entered into is that the parties agree on the procedural approach to the proceedings in a particular context. Having reached that agreement, they put that before the court for the court's approval. The court then reviews it. Often, because it's by consent, there will not be much difficulty in agreeing it or in the court issuing the order, but ultimately it's the court that issues the order. It has never been said that that gives rise to a separate, enforceable, private right between the parties, independent of a court order, that is somehow enforceable. There is simply no authority for that.
If you want to assert that broadly, then so be it.
Well, it's not that I'm asserting a proposition for which the argument I'm making is that a proposition of law has been made by Leadingway for which your lordship has no authority. So the burden is on them to demonstrate where this approach is recognised in law. If one was to approach it on a contractual basis, let's just step back and understand the reality of it. What are we talking about? Are we talking about how does one analyse the consent order in terms of a contract? Where does implied terms feature in that? Where does offer and consideration feature in that? Is there sufficient consideration in that? Is there an intention to create legal relations per se between the parties in that? That is what a contract is about. An agreement to enter into a consent order is a very different thing. I suppose, hypothetically, you could have a very, very bespoke situation in which the circumstances that led to the parties agreeing a consent order would independently give rise to a binding contract. That, I imagine, is in principle possible. In order to get that far, you would have to go through the traditional contractual principles, demonstrate that the traditional contractual principles of offer, acceptance, consideration, and intention to create legal relations existed. And then you would have to consider, supposing that it did, you'd have to consider the consent order in the context of other contractual principles such as implied terms and the like. Now, there isn't even the beginnings of an argument to that effect made to you by Leadingway for the purpose of demonstrating that this consent order by Mr. Justice Foxton is in effect, or is actually not in effect, but is a contract. More importantly, that argument was not advanced before Mr. Justice Knowles. It is therefore not open to Leadingway to criticise his judgment on the basis that he did not approach stage 3 of Denton's in that way.
I haven't read the skeleton arguments below in full, but just glancing at claimant skeleton below, page 62, paragraph 37.
I'm sorry, paragraph 37?
Paragraph 37.
Page
Behind,
62.
Page 62, behind tab 8.
Yeah. Well, the point we made here, my lord, it's a very clear one in my submission in my favour. It's being argued here that the language there, sorry, let me just,
Sorry, we have paragraph 37 on page 62.
Yeah.
Is that dealing with the written agreement underlying the claim?
Oh, I see. It's the substantive
I
agreement.
don't think it's
not-
dealing with the. I don't think it's dealing with
Right.
the.
Sorry. So you say that it was never suggested to Mr. Justice Knowles that the fact of the order of Mr. Justice Foxton being something which the parties had agreed, it was never put to Mr. Justice Knowles that that was a highly significant point in the claimant's favour?
No, I don't. We will check. We will check as to that. But the particular point I'm making now is that it was never argued before Mr. Justice Knowles that the Foxton consent order was a contract that, if I understood the argument being put this morning correctly, that gives Leadingway personal private rights that would be taken away from it if the application for relief from sanctions was granted to Michelle. That was certainly one of the ways it was put this morning. It is not a contract. That was the point that was not argued. The contract point was not argued before Mr. Justice Knowles. The fact that it was a consent order was clear to him because it's apparent from the face of the Foxton order.
Yes. Do you submit that the fact that the parties had agreed that if an application was not made within the specified time, let's park the 1 day for the moment, do you say that the fact the parties had agreed what sanction would follow is irrelevant?
No, I don't say it's irrelevant. It is something that can be taken into account at Denton stage 3.
Yeah.
As can the fact that this consent order was not made following any prior breaches of court orders. Often you will find, if a consent order is made of this kind, that it's the last chance because other court orders have not been complied with by one of the parties, by the respondent to the order, if you like.
Yes.
So yes, it's perfectly legitimate to take into account the consent nature of the order at stage 3. It is also, in the context of this particular consent order, relevant to take into account, as Mr. Justice Knowles did in paragraph 4 of his judgment, that there had been no prior breach of that order.
But if it's relevant, as you can see rightly, if I may say so, that the parties had agreed the sanction, why doesn't the judge refer to it?
Well, first of all, my lord, as I stated at the outset, this was an extempore judgment. It was one of 4 applications he had to deal with it. He does say specifically at the end of his judgment, paragraph 10, if you look at it, looked at in the way that I have in brief reference, but having very much in mind all of the points made orally, writing and orally, this application for the second defendant will be granted. So he's making the obvious point that of course he hasn't addressed every single relevant issue that was in play on the day, but that is not, he's specifically recording, that is not to say that he has not borne it in mind. And to imagine that he would not have borne it in mind when the words consent order are there in black and white, and the agreement of the parties is there in black and white on the face of the Foxton order is we respectfully submit, unrealistic.
Well, actually, it refers to the fact it's by consent in the second sentence of paragraph 1.
I'm very grateful. I'm very grateful. Lord, I would respectfully adopt that point. He'd not forgotten about it.
Can I ask, the parties had simply agreed an extension of time,
Yes.
then the effect of the relevant rule part 11 is that if you did not serve your application by that date, then you would be deemed to submit to the jurisdiction and you would be out of time for your defence, so they could apply for default judgment.
Correct.
So it seems to me that, do you accept that by agreeing that it would be in unless order format with specified consequences, that the parties must have intended to denote something more than would simply be denoted by a straightforward extension? What is it you suggest they are denoting?
Of course, they're denoting exactly what the order says in the terms that the consequence of not doing so would prima facie be as stipulated in the order. That
aren't they denoting that this is the end of the road? We've given you a number of extensions. We've now consenting to another extension, but this really is the last, and we're both agreeing that we've got this one last. We're actually going to give you longer than you've asked for, because this really is the end of the road, and that's exactly what the parties intend to convey by agreeing these rather draconian words that in fact aren't strictly necessary, because an ordinary extension would have had the same effect. But what they're saying to each other and to the court is this far and no further.
I don't disagree with that analysis at all. But what I would add to it is that notwithstanding that agreement, and consistent with the approach of Lord Justice Morbick in Marcan, when, however, a breach occurs, if and when, however, a breach occurs, it is still relevant, even in the context of the parties' agreement to a consent order, to consider the extent of the breach and the reason for it at part
I
of
accept
stage
that
3.
entirely, but the point I think the point is, the judge does not seem to have taken into account the fact that this was a this far and no further agreement between the parties, embodied in a consent order that the court was asked to approve, and that they hadn't just agreed another extension of time, which would have resulted in a relief from sanctions application, but had used wording, which it seems to me in the context of jurisdiction and the quite clear-cut provisions of Part 11 as amended in commercial court, where you get a longer period than the 14 days. The judge doesn't seem to have given any consideration at all or weight to the fact that this wasn't just an unless order. This was an unless order which the parties had agreed and which they didn't need to be for. The rules provide effectively for the unless order consequences. This is the parties expressing more. That he doesn't seem to have taken into account at all.
My lord, I would respectfully submit that is would be an unfair analysis of Mr. Justice Knowles's approach, because, as was kindly pointed out, in the very first paragraph, he notices and records the fact that the order in question is a consent order.
He doesn't seem to have given any subsequent effect to. I mean, he doesn't seem to have regarded that as impacting upon any of the other analysis.
Well, he understands it's a consent order. He refers repeatedly to the fact that it's also an unless order. He knows, ergo, that what he is dealing with is a situation where the parties have agreed a way forward in respect of the jurisdiction application in unless terms. Now, the fact that it's in unless terms makes it clear that what they have agreed is that, as things stood, and without being able to predict the future, this far and no further. But the this far and no further point is one that always arises in an unless order situation. And we know from the case law, and there are examples in the authorities bundle, that does not, however, preclude the court in the context of a relief application from saying, now that we know the circumstances of the breach, which obviously were not apparent at the time that the parties agreed the consent order, is it just in all the circumstances to grant relief? And that is what precisely Mr. Justice Knowles was doing when he undertook his evaluation. Consent order, yes. Unless terms, yes. But I am now dealing with a one-day breach arising as a result of inadvertent mistake by those trying to do their best. Those were the factors he took into account in coming to the view that it would not be just, paragraph 9, in all the circumstances to refuse relief. And the fact that he didn't analyse it in the level of detail as your lordship has done in terms of the consent aspect of it cannot fairly be deemed to be, it cannot fairly be inferred from that he didn't take it into account, because a judge isn't expected to recite all of the arguments put before him. He made it clear in paragraph 10 he was taking into account all of the arguments put before him, even if not in the judgment, and we're dealing with an extempore judgment.
Yes, well, of course that's right, but you wouldn't say, would you, that paragraph 10 is a blank check, that all a judge has to do is say, I've heard excellent arguments from Ms. Bingham, Mr. De Cruz, I take them all into account, I'm going to grant the application.
Yes.
That wouldn't be enough. So he's clearly applying Denton, reference to stages, and he says, quite rightly, unless order, therefore treated as a matter of seriousness or significance. Stage 1. Stage 2. Reason for default, it was inadvertence. Mitchell, rightly or wrongly, says if it's a mistake, you still fail at, you don't get out of trouble at stage 2, you go on to stage 3.
Correct.
Stage 3, paragraph 7, he acknowledges that it was an inadvertent mistake, that's relevant. 8, he says he's troubled by the limited nature of the second defendant's evidence. And then the guts of the decision, as it seems to me, is paragraph 9, first sentence.
That's where he summarises.
Well, that's it. It's not just summarise. If I look at all the circumstances of the present case, I cannot accept that they lead to a conclusion that a just approach is to refuse relief from sanction.
Yes. And all of the circumstances must include, I would respectfully submit, the fact that it was a consent order. That must follow from the specific reference to it in paragraph 1. And the fact that it was an unless order, referred to twice in paragraph 2, as your lordship quite rightly points out, the consequence of that, his lordship, Mr. Justice Knowles, said it makes it serious. So he wasn't by any means ignoring the seriousness of the situation before him, that this consent order had been breached. He took that into account as part of all the circumstances that he refers to at the beginning of paragraph 9. He must have done, because they are recorded in the earlier paragraphs of his judgment. He came to the evaluation that nevertheless, given in particular the factors referred to in paragraph 7 of his order, and I'm sure he would have taken into account the fact he was dealing with a 47 million euro judgment, and there had been no disruptive effect of the breach. It was just in all the circumstances to grant relief. He took all of the relevant factors into account in my submission. And one can get that from the judgment itself.
Just to put the counter to you.
Yes.
If they had in mind unless order in the context of looking at whether it was a serious and significant breach.
Yes.
It qualifies that by saying, but it was not following prior breaches, but does follow prior extensions. And then the question of reason, whatever. But then he comes on to, when he comes on to looking at all the circumstances, he doesn't come back to or seem to take into account at all that this was a consensual unless order.
Lord, Mr. Justice Knowles doesn't identify any specific circumstance in that sentence, or indeed, I think, in that paragraph. So what he's clearly indicating is that he's taken into account, the circumstances he's taken into account are not just all of the relevant circumstances in this case, but specifically that they include the background that he has set out in paragraphs 1 to 8. It cannot be said, I mean, if one is to take that to its logical conclusion, then it would follow that he didn't take into account the inadvertent nature of the breach, that it didn't have any disruptive effect, and it was by parties trying to do the right thing. But the fact that he didn't, obviously he did take that into account because it is the core logic of his approach. And one must, I respectfully submit, be careful not to get into exactly what I think Plotski has said, avoid a narrow textual analysis of the judge as a pretext for revisiting the exercise of his discretion. It's the easiest thing in the world to cherry pick from a judgment and say, well, he refers to this, but not that, and say, therefore, he got it wrong. It ignores the presumption that the judge, the starting point, which is the judge knew what factors to take into account and what factors not to take into account. And it's only if the judgment plainly shows that the judge took into account a relevant factor, or plainly shows that the judge did not take into account a relevant factor, that this court should entertain exercising its own discretion and imposing that in replacement of Mr. Justice Knowles's. Right. I'm told Mr. Lewis has analysed it. I'll have to analyse it myself. But in the claimant's skeleton, despite the fact that there were references to the fact that this was a consent order, I'm talking about the claimant's skeleton before Mr. Justice Knowles, despite the fact that there was an analysis that this was a consent order, there wasn't the sort of argument that is now being made, that therefore that was a significant factor that should be weighed in at stage 3 and override all of the other factors. And I'm told...
I think you can also make the point, I'm not sure it's in the grounds of appeal either.
There are a few things that are not in the grounds of appeal that have been argued today, including prejudice. I'll come to that, arising from the orders made. And it wasn't developed in the transcript. So what one is dealing with now, let's just step back and understand this. New argument based on as a reason for inferring that the judge didn't understand what he was dealing with in respect of an order that he refers to in paragraph 1 of his judgment as a consent order, and twice in paragraph 4 as an unless order. Now, if judgments are overturned on that basis, your lordships are going to be very, very busy.
Well, I have to say that, just thinking back to I can't remember very many cases where parties who had been ordered to comply, given a less order in relation to a date for serving an application contesting jurisdiction in commercial court, then failed to comply with that and then sought relief from sanctions. I don't think it happens very often.
It's a very narrow category, my lord, but I can give you certainly examples of cases where the court has granted relief from sanctions for breach of an unless order.
Yes,
say.
we're talking here about jurisdiction,
I understand.
which is,
Yeah.
it's a very clear-cut thing that you're served with the proceedings, and you have immediately you have to acknowledge service and say whether you intend to contest the jurisdiction, and then you have a quite limited time in which to make your application, even though you're by definition overseas. 14 days under CPR 11 and 28 days in CPR 58, whatever it is. Your client had extension after extension after extension, then agreed to an unless order, and now comes back saying, well, actually, I still want to contest the jurisdiction. That, in my experience, is quite an unusual scenario, not one I think we need to be troubled about floodgates.
Well, can I just pick up one point, which is that if your lordship is saying that Michelle is still seeking to challenge the jurisdiction in relation to this claim, that
No,
right.
no, it's the fact that he was holding open the jurisdiction challenge,
Yes.
which enabled him to push off serving a defence.
Yes, I understand your lordship's point.
And I think there is what seems to me, and maybe an element of what is lacking in the judge's approach to this, is any appreciation of the fact that we don't have just any time limit here. We have a time limit for challenging the court's very jurisdiction in the matter, which by the rules is he's deemed to submit to the jurisdiction by a particular date if he doesn't challenge jurisdiction. And if he doesn't challenge the jurisdiction on that day, he's here, and there's no more. There's no question after that of saying I'm challenging the jurisdiction. And here, not only has that date arisen, but it's arisen in circumstances where he's expressly agreed that he can't challenge the jurisdiction. And it's an unusually forthright position.
I understand the way your lordship's putting it. I will just say that's not the way it was put before Mr. Justice Knowles. The question for your lordships is it appropriate to interfere with his discretion? And that analysis can only properly take into account his approach, having regard to the arguments that were put before him. It will be wrong to say the judge failed to take into account an argument that was not put before him.
I think, adopting some of your line, I think we can assume for certain that Justice Knowles understands what's going on with jurisdiction.
Well, he may well do, but to focus on that, on all the, if I may say so, very nuanced points that your lordship is has just identified, and to say, I'm not sure whether the point being made is that he did take that into account or didn't take that into account, but to suggest that he should have taken quite those nuanced points into account in circumstances where they were not being made to him by either party. I don't think that's a basis for criticising or overturning his decision. We are here to analyse the correctness of Mr. Justice Knowles's reasoning, his evaluation at Denton Stage 3, in the context of the cases that were put to him on the two applications, set aside and relief from sanctions. Did he get it wrong in that context?
having addressed us on points which were not taken by Miss Bingham below, who say, do you want to go next to the respondent's notice?
Well, the respondent's notice, but there are 2 points that we make in relation to the respondent's notice. One relates to the way in which the consent order was drawn up,
Yes.
and that it did not comply with the practice directions, paragraph 8 of the relevant practice direction, which
Yes.
requires, I think it's set in mandatory terms, it requires that a date be set out in the order specifically in relation to an action that requires compliance. Now, that is critical in relevance for our purposes, because as we know, the reason for the mistake was looking at the sealed order date, or the date of the sealing, rather than the date of the actual order itself, just underneath the name of Mr. Justice Folkestone. That, it is inevitable, that mistake would not have occurred if the precise date for filing of the jurisdiction application was recorded in the body of the Folkestone order. Now, of course, we're addressing this in the context of justice in stage 3, at stage 3. We know that the order was prepared unilaterally, I should say, unilaterally by Leadingway solicitors. And it was prepared without referring to the date. It's said against me, initially it was said that it's our fault that we didn't pick it up. And then it was, I think there was a slight movement, it's the joint responsibilities of the parties that this mistake was made. The burden of responsibility here.
Well, just on the facts, do you accept that the original draft came from Mishcon de Rea?
Yes.
And then it's sent to your
Yes.
solicitors who agree to it?
Like so. Like so.
Right.
That's the sequence. That's the sequence. But the obligation primarily lies with those drafting the order to make sure when they turn their minds to the actual drafting, it complied with the practice directions. I would ask your lordships to bear this in mind. At the date when my instructing solicitors received it, they were not officially on record. They were providing, the evidence shows, very limited support, poor essential support to Michelle, whilst the complication of agreeing an engagement letter was in process. And I say that because to say that just adds to my argument in my submission, that to say that there was even equal responsibility for this mistake is wrong. It's unfair in the facts. So the primary responsibility for it is Mishcon's, it's Leadingway's, and Leadingway is now seeking to take advantage of that mistake, their primary mistake, through the position they're taking in this application, below and in its appeal. And that is, we submit in broad terms, iniquitous. It's a Denton stage 3 point. It's not a point that the judge identified, but it was a very valid point on which his decision could properly be based. Matter of practical justice. Stepping back, what one's talking about this is it fair in the round to deprive Michelle from the opportunity of defending a 47 million euro claim because of a one-day mistake caused by a focus on the seal of an order rather than the date of the order, when that order prepared by the claimant failed to identify the precise date for compliance, and had it done so, the mistake would never have been made and there would never have been a breach. In that context, I respectfully submit it would have been unjust for Mr. Justice Knowles to have refused relief, but that's not the question. The question is the approach he took in that context so plainly beyond the realms of conclusions that a reasonable judge could have reached as to justify this court stepping in and overturning it? In my submission, plainly not. Lord, I was going to deal very briefly with, I think I've dealt with, yes, grounds 3A and 3B. I just want to deal very briefly with grounds 3C and 3C firstly, which is the point being made about well-meaning incompetence, or a breach arising out of well-meaning incompetence should not usually attract relief. I don't think that was pushed very far, and rightly so, this morning, because it's plainly wrong. The substance of that argument is, once you have a breach of an order, and assuming it's serious, and you don't identify a good reason for it, because that reason relates to a mistake, that's the end of the inquiry. And that's obviously not right. Or even, it's usually the end of the inquiry. And that's obviously not right. The correct approach is the trite one. You move on to Denton Stage 3, you take into account all of the relevant circumstances, and at Stage 3, the fact that the mistake was not that of the party is most certainly a justice point to be taken in favour of granting relief. And we see that, in fact, in Hussein, I think it was. Just quickly look at that. Tab 3.
Yes.
And if I could ask you just to look at paragraph 35, page 42. You will see there that there's a checklist. The judge identifies a checklist of factors to consider. The first, that the application was not made promptly. The second was a failure to comply. The failure to comply was not intentional. But it occurred through incompetence rather than through deliberate intention to flout court orders. Then D, there was no good reason for the failure. And some reason it goes from D to F. But F, it's impossible to say that the failure was caused by a legal representative. So in my submission, the point being made there is that if that is the cause of the failure, then yes, it's a fair thing to take into account at Stage 3.
This is, I don't think Miss Bingham was suggesting that incompetence cannot be taken into account at Stage 3.
Well, the grounds of appeal on which she received permission say that Mr. Justice Knowles failed to recognise that well-intentioned incompetence should not usually attract relief. And it's been said, or rather at least the logic of that argument, is that as a result, he should have moved straight on to refusing relief. I don't want to spend much time on this because certainly the proposition, if it was being made, if it's not, then that's fine, that you don't go on to Denton Stage 3 and take into account all the points that Mr. Justice Knowles did take into account in granting relief. That's wrong.
Well, I think the point that can be made is that in paragraph 7, the judge seems to have thought that it was a factor that the inadvertent mistake was those trying to make the application, trying to do the right thing.
Yes. And he was right to do so. I understood Miss Bingham to be saying, I may be wrong, that the judge shouldn't have taken that into account. It was a mistake, and that's the end of it.
Well, I think the point she was making is that all this amounts to was an inadvertent mistake. Trying to get the timing right is a slightly odd thing to say when what they were doing was, even on their own case, leaving it to the very, very last minute.
Well, that's a slightly different point. That's a point made this morning. It's not the point that was made in the grounds of appeal. But as far as this morning's point is concerned, of course they were trying to do the right thing. They were attempting to file the jurisdiction application by the date that they thought was applicable. Of course, that turned out to be incorrect, but they were still trying to do the right thing.
But isn't trying to do the right thing always going to be the case if there is a well-intentioned inadvertent mistake?
Well, it depends on the nature of that mistake. If it falls broadly within the same category, then this can certainly be said of it. This is a glaring example of trying to do the right thing because there was a genuine belief that the deadline was, I think it's the 21st instead of the 20th of December, a genuine belief and an obvious effort to file the jurisdiction application by what was thought to be the relevant deadline.
Well, I think what you can say is that because the mistake was thinking that the deadline was the 21st rather than the 20th, it's plain that what the intention was to file this at the very last moment.
Well, within the deadline. I mean, if I take on what I think your lordship has in mind, which is the very unfair inference that because it was left to the last day of the what was thought to be the deadline, it was somehow gaming the system. I mean, that's, with respect, nonsense.
Well, I think the point is if you agree to an unless order,
Yes.
and then you leave it to the very last moment, you are certainly acting in an extremely risky way.
Well,
And to some extent, you are gaming the system.
But
because what you're trying to do is get yourself the very maximum time before you actually have to serve a defence.
But the danger in that approach, and certainly in characterising it as leaving until the last minute, there is an inference there that somehow those that were preparing this were sitting on their hands without any reason, and that there wasn't actually proper work being done to prepare it, and there's absolutely no inference. No evidential basis for such an extreme extreme conclusion to be drawn, and it's a very unfair conclusion. And again, what you're asking, the context of this is, should Mr. Justice Knowles have approached it on that inferential basis? There's no justification for that. Many of these arguments are very understandably being landing and having the immediate effect of analysing the discretion afresh. But at every stage, it is very critically important for your lordships to say, was this an argument raised before Mr. Justice Knowles? Is it clear that he didn't take it into account if it was relevant? And unless the answer to those two points are yes, then there's no basis for interfering with his decision. Now I deal quickly with the obligation to be candid, which is ground 3D. again, I don't think I need to spend very much time on this, because the point I was going to make is I think the point that Lord Justice Phillips made this morning, which is that what is the information that is said to have been withheld here, and how is that relevant to the breach? Those are the points.
I think we were all of the view that insofar as Bingham was putting forward supposed duty of candour in the sense of which it's used on applications without notice, that's simply not appropriate. You would, if it means that the second defendant, she says, gave extremely thin reasons for then Justice Knowles, I think, does deal with this, doesn't he? He mentions it.
Yes, he does. He it's the longest paragraph of his judgment at paragraph 8.
Yeah.
He specifically focuses on that. That shows that he had it firmly in mind. Therefore, there's no reason to believe that he approached the issue wrongly in terms of failing to take into account a relevant factor. But I would ask your lordship very briefly to recognise the irrelevance of what it is being complained was withheld in terms of information. The information has got to relate to the reasons for the breach, if it is to have any relevance at all. The breach here, one-day mistake due to focusing on the seal as regards the date. So the argument that Michel should also have explained in his evidence in graphic detail the reasons for the difficulties he had in obtaining legal representations and the steps that he'd taken to do it in terms of financing and who he'd approached, etc., etc. It's a world away from the actual breach. This is a contrived argument. It's a pretext for criticizing Michel in relation to his evidence. The judge found that the breach was serious. As a result, it was necessary to go to stage 3 and persuade him to exercise his judgment. That's the only effect of the breach. And so what, in effect, Leadingway is trying to do is to punish Michel twice for this. Twice in the sense that the judge identified no good reason for the breach. Therefore, you don't satisfy. You have to get past stage 2. Once you get past stage 2, which is the only the issue here, everything's in play. You take into account all the relevant circumstances. So this candor point goes nowhere. And it's aligned to, or closely related to, the final point in relation to D1, which is a criticism that he'd done nothing to progress the instruction of lawyers. And it said that the judge failed to recognise that supposed failure. Didn't take independent steps to instruct lawyers. But again, that has nothing to do with the breach. It was not that supposed failure that caused the problem in this case, that caused the one-day delay in filing the jurisdiction. It's to do with
3E now.
I'm sorry?
Isn't that 3E?
Yes, did I say something else? 3E, yes.
I think you said the last point against the first defendant.
Oh, I'm sorry, second defendant,
Yes.
Michel.
Yes.
Lord, unless you have any further points, I simply conclude in relation to Michel. I simply conclude with this. The ultimate question for your lordship is to consider whether Mr. Justice Knowles was entirely wrong, palpably wrong, when he came to his evaluation that it would be unjust to refuse Michelle relief to defend a 47 million euro case, a case that had been demonstrated has a real prospect of success in terms of defense because of a one-day deadline in filing his jurisdiction application, because that, in the context of that having arisen as a result of an inadvertent mistake by those trying to do right, when there had been no prior breach of any court order or any deadline by Michelle, no breach of any previous rules, and the breach had not had a disruptive effect on the proceedings, and finally, in circumstances where Leadingway has not, then or today, identified any prejudice that it has suffered as a result of that one-day breach. So stepping back, the argument that Mr. Justice Knowles acted quite wrongly in granting relief in that context is, I respectfully submit, unsustainable. That is the appellate question for your lordships. I'm now proposing to deal with the position of Fareed.
Yes.
Now, the first complaint made, round 2A, is that Mr. Justice Knowles, it is said, failed to recognise that a claimant is not likely to be deprived of a default judgment regularly obtained, and that the burden lay on Fareed in this regard. So for this, we just need to keep our thumb now in tab 11 of the core bundle, where you'll find the judgment in relation to Fareed. I make all the same points without repeating them, relating to extempore judgment, relating to avoiding a textual analysis, and assuming that the judge was aware of the relevant factors, unless it is demonstrated to the contrary. Now, significantly, on the burden point, what Leadingway does not identify within the judge's analysis in his judgment is anything about his approach that suggested he thought the burden in this application lay anywhere otherwise than Fareed, i.e. on Leadingway. That would be a quite remarkable mistake for the judge to have made. He plainly did not, and you can see that by the specific conclusions that he reached. Firstly, in paragraph 7, first part of the judgment just deals with the real prospect of success, but if one goes over the page 88, paragraph 7, he finds that the delay was serious or significant. So he's approaching that on the basis that it's not for Leadingway to prove that it's serious or significant, it's for me to have proved otherwise. Burden on Fareed. Then, in paragraph 8, he took the same approach as to whether or not there was a good reason for that delay. And he says not. Clearly recognising burden there lay on Fareed and not Leadingway. And then in paragraphs 10 to 12, he addresses stage 3 and whether it was just in all the circumstances. And he focuses specifically on the fact that an identical claim against Michelle will be proceeding anyway. He then concludes in paragraph 13 that having weighed up all of the circumstances, he was satisfied that justice requires setting aside the default judgment, and I'll come back to this in another context, so that the real issues in relation to both defendants are considered on the merits. In other words, the way he was approaching stage 3, logically, and as you would expect, is whether or not Michel had put forward to him, I'm sorry, the same Michel, I should be saying Farid, whether Farid had put forward to him sufficient factors to persuade him at stage 3 to grant relief. Again, burden firmly on Farid. So it's clearly wrong to say that the judge did not recognize where the true burden lay in this application. This is another contrived argument with respect. And having recognized and analyzed step by step each stage and whether or not the burden had been shifted, that itself was a recognition by the judge of the principle that we are all aware of, that a default judgment is not likely to be set aside, regularly obtained. So we say there is no substance to that complaint. It is factually incorrect. You can see that from the judgment. That's 2A. 2B. 2B is the complaint that the judge failed to take into account promptness, or that he failed to attribute sufficient weight to it. But again, it doesn't take very much to see that it also is factually incorrect. In paragraph 1 of his judgment, he identifies very clearly at the end of that paragraph, CPR 13.3 expressly goes on to provide all the matters to which the court must have regard, including whether the person seeking to set aside the judgment made an application to do so promptly. In the present case, the period is a very substantial one. Promptness was one of the first points in his reasoning, or in his consideration, I should say. He then returns to the point in paragraph 13. He says, weigh up all the circumstances with the benefit of what I've read and heard, and bring into the discretion and bring that into the discretion that I have to exercise. I absolutely keep in mind that in the present case, the person seeking to set aside the judgment did not make an application promptly. He starts with promptness, he ends with promptness. It featured very significantly in his thinking. So to say that he didn't take it into account, factually wrong, and when one can see the emphasis that he put on it, I absolutely keep in mind the need to make the application promptly. It is clear that he also placed great weight on that factor.
Yes.
Now,
He seems to put on the other side of the balancing exercise the fact that the second defendant, if the judge was right to allow the second defendant to defend, what can we call the finality point, or lack of finality point? Does he put anything else into the balance on?
let me just
your client's side?
let me just check. What he does do, what he does recognize, my lord, in paragraph 12 is that there are cases where the sense of finality is a very real one, and where it's only fair and important for the rigor of the system. They're identifying the importance of compliance with rules. He had that in mind. He says, not in the present case. Then goes on to say there may be cases, of course, default judgment stands even though there's something real about the merits. So I think, yes, it is fair to say that the issue that tipped the balance, in his favor was the finality point. But within that finality point, and it is a factor that he referred to expressly as regards Michelle, and therefore you can reasonably infer he took into account here, was the lack of disruption. The lack of disruption, by that I mean that the fact that the default judgment would be set aside against Fareed would not disrupt the proceedings that would be continuing against Michelle. That's what I mean by lack of disruption. And here can I just address a point that arose in the morning? It arose in the context of what approach the court should take as to whether the claim against a co-defendant is actually going to proceed. Should you presume that? I think that's the point that Ms. Bingham is stating, is arguing. Now, it's important to stand back and understand the logic of that argument and where it takes you. Because the logic of it is, if a co-defendant, I call him the defaulting defendant, if a defaulting defendant applies reasonably early in the process of the claim against the co-defendant, the court should somehow not assume that the claim is going to proceed against the co-defendant, therefore dismiss the co-defendant issue. Whereas, if the defaulting defendant applies late in the day, on the cusp of a trial, somehow that defaulting defendant is in a better position. Can't be right. Can't be right. So,
Well, if it's on the cusp of the trial, that might be a very good reason not to grant.
precisely, because of disruption.
Well, because of disruption. I think it's also fair to say that the fact that it's early in the proceedings, I think was suggesting that one could not be confident that the claim against the other defendant would go to trial. It's not clear to me why it's necessary to consider whether it would go to trial. The mere fact that proceedings would proceed, possibly to a settlement at some stage, would mean there wasn't finality at that point. I think the more difficult thing I find about paragraph 11 is what does the judge mean when he says there was no real sense of the proceedings or the dispute as a whole being over? Who is it who has the sense, and when do they have the sense that the proceedings were over? When do you judge that?
Well, I think it would, to be fair to the judge, the simple point he was making is, taking into account what he says at the beginning of paragraph 11, the continuation of proceedings against the second defendant. That's the context in which he makes the comment at the end of the paragraph. In the context of a claim against the second defendant continuing, there is no real sense of the proceedings or the dispute being identical as between Michelle and Fareed on the one hand and Leadingway on the other hand, as a whole being over. He's clearly talking about the ongoing claim against Michelle, which by that stage he had determined should continue.
I find it quite difficult because there's no doubt what the situation is, and any lay or lawyer will understand the position was that there's a default judgment against the first defendant.
Yes.
And the claim against the second defendant is continuing. That's the situation. I don't understand the classification of saying the proceedings or the dispute being over or not. Over against the first defendant and not over against the second defendant.
Yes, and he was viewing it in the context of the dispute as a whole. What he had in mind, I submit, was this reality. Given the claim against Michelle is proceeding to a trial, Leadingway is going to have to, at that trial, battle it out with Michelle on the issue of the oral agreement, what took place at that meeting, with the Swiss representative, a meeting which I think your Lordship has the point early this morning, involved Farid and not Michelle. So Farid would have to come to give evidence for that purpose.
But you wouldn't have to.
He wouldn't have to, but the reality is that he's very likely to.
The big point, isn't it, is that if the defendant pays the judgment, then there won't be a trial against the second defendant.
If the first defendant pays, well, that's a hypothetical, of course, but that would be the position in very many co-defendant cases. The point is this.
That's why it seems to me the concept of whether the dispute is over when you've got judgment against one defendant is a slightly difficult one to grasp, because it depends whether or not you can enforce against that defendant, whether the second defendant has assets.
Yes, and
I'm not sure. I can see that at the later stage of the proceedings, you might say, well, this issue is going to be tried relatively soon, and you might as well have the first defendant. It's so early that one's absolutely no idea. The idea of saying that this should have to go to trial because you want both of these defendants there, so therefore it isn't just for the default judgment to be against the first defendant, is a bit fanciful.
I don't think Mr. Justice Knowles' analysis was quite that. I don't think he was saying that he would set aside the default judgment because it's better to have both
As he
defendants.
says in paragraph 13, in the present case, is to set aside default judgment, allowing the real issues.
Yes. Forgive me, I might have misunderstood your point, my lord. If I thought your lordship may have been saying that part of his thinking was, let's set aside the default judgment against Farid so that he will attend the trial, which would be relevant for Michelle. That's not his approach. In my submission, his approach was, these issues are going to have to be thrashed out by Leadingway anyway. All the same issues. Leadingway is not going to be, it's not going to say anything in terms of costs or anything in terms of delay.
It may, because if they can enforce the judgment against the first defendant, you won't have any of these costs.
Well,
or the delay.
There's a lot of hypotheticals there. There was no evidence before Mr. Justice Knowles of any of that bringing finality. On the contrary, the situation before him was that a default judgment had been issued long before the hearing, and there was no suggestion of enforcement or Leadingway receiving sufficient monies such as to make it unnecessary for them to proceed against Farid. The only information that the court had was, on the contrary, despite default judgment long ago, Leadingway was determined to pursue a claim against an additional claim against Farid. And there's nothing that you have heard, even today, to shake that determination. Factually, therefore, the only proper basis for pursuing this, and in fact, the proper question to ask is, for Mr. Justice Knowles to have pursued it, is to say, I assume the case is going to go forward. That is clearly the claimant's intention.
What seems to be remarkable here, and I'm not sure the judge did take this into account, was that the judgment against the first defendant was entered into in April 2022.
I think so.
So the claim as against him was done and dusted, judgment entered.
I'm told August.
Sorry, so yes, it was served in.
I think it was served. It's been April next year. The chronology is here.
August. Judgment in August.
Yes. Thank you. Page 75 of the core bundle, 26th of August was when the order was served 4th of August was when. Thank you.
So judgments had been entered against him before the proceedings against the second defendant had been served months and months before.
Yes.
Now, when you've got judgment against one defendant, you haven't served the other defendant. Obviously, you don't have to serve the other defendant. So there undoubtedly there was finality here for months and months and months, wasn't there? It's only because ultimately the second defendant was served and didn't succeed in the jurisdiction challenge that in some way the non-finality is against the D1 revives. And I think that's the difficulty here, is that this you know, that on one line you could say that the claim against the first defendant was finally determined by default judgment long before his application is set aside. Why should questions of trying it together with the second defendant revive simply because at long last the claim against the second defendant has been served and he's failed in his jurisdiction challenge?
The answer to that, my lord, is because Denton Stage 3 required Mr. Justice Knowles to consider all of the circumstances as they existed at the time of the hearing before him. And at that stage,
where does the judge take into account that the first defendant had taken absolutely no steps whatsoever to deal with this claim for many months, despite dealing with lots of other litigation on his own explanation, allowed the judgment to sit there for many months, and is now only coming now to seek to set it aside at a time when the possibility of the claim being brought against the second defendant arises.
the context of all of that is reflected in paragraph 7 and 8. I will reflect this a bit. In paragraph 7, the judge identifies that the delay was serious or significant. In paragraph 8, he identifies that there was no good reason for it.
No, it doesn't seem to have featured at all in stage 3. He seems to take into all he takes into account is all he considers in stage 3 is whether or not there was finality in the proceedings.
Well, all he is recording, or the only reason he records as specifically as his thinking, as part of his thinking in stage 3, was that point, was finality. That does not mean that that was the only issue he had in mind. He says in paragraph 13, I must weigh all of the circumstances with the benefit of what I have read and heard, and bringing that into the discretion that I have to exercise. We're back to the point that just because the judge does not set out in a full list, in any list, the issues, the specific issues he had in mind, that is not a basis for inferring that he failed to take into account relevant points. In fact, that approach is entirely contrary to the appellate, to the case law on the proper appellate reasoning in this sort of situation. There were a plethora of arguments that were put before the judge that were not identified by both sides. He didn't do it in his extempore judgment. I've already explained the reasons for that, very understandably. They are not a basis for overturning that judgment.
One more go, just to make it clear, the counter-argument. When the judge is discussing finality in the latter stages of his judgment, he doesn't seem to have taken into account at that stage the fact that this claim against the first defendant had been done and dusted and over for a year, and that the first defendant had done nothing in relation to that judgment, knowing about it for over a year. And that seems, I thought, is a relevant factor, a highly relevant factor in considering whether or not there was finality on whether or not the first defendant should be permitted to revive a defence to a claim that he has elected not to defend and not to set aside the judgment for an unconscionable period of time. And he hasn't taken that into account at all at stage 3 in considering whether there was finality.
I would dispute that for one reason, my lord, with great respect. The fact that he hasn't referred to it doesn't mean he hasn't taken it into account.
We're back to the same argument as paragraph 10 of his judgment in relation to D2. I'm exercising a discretion.
Yes.
Stage 3 of Denton requires me to take into account all the circumstances. I've taken into account all the circumstances. I have decided to grant straight refuse the application, and this court just has to, you say, assume that an experienced judge granting an extempore judgment has taken into account all that he should have done and nothing that he shouldn't have done.
Lord, yes, when the arguments were clearly put before him, when they are prominent arguments that were put before him, and unless the judge has demonstrated to the contrary, this is the case law appellate guidance, unless the judge has demonstrated to the contrary in the judgment, yes, you assume that the judge has taken into account all of the relevant circumstances, particularly where it's an extempore judgment, particularly where the judge has expressly stated that he has weighed all the factors into account. My attention was drawn to paragraph, Mr. Lewis, also to paragraph 10, where the judge records this, that I bring back in the reasons for the delay at stage 3. So he's gone back to the reasons for delay, specifically in stage 3, when they were not available as good reasons at the second stage. I do not regard them as having any real weight over the period of time. Exactly your point, my Lord Justice Phillips. Over the period of time within which we are concerned, taking everything into account, there is not much mitigation. So he's recording there, specifically at stage 3, that he is focusing on the inaction over the period we are concerned with. I think that addresses one of your points, my Lord.
Well, I'm not sure,
but not the second one.
I'm not sure it really does. I mean, that's where he's saying he's rejecting taking into account on the first defendant's credit the reasons for delay, the excuses, the mitigation. What he's not taking into account in considering finality is the fact that the judgment was entered in August 2022.
Okay. Mr. Lewis has drawn my attention to part of the transcript before the judge where this issue was addressed. So it's supplemental bundle, I think it's 14.
Yes, 14, 121.
What page?
121.
121.
Starting at C.
Forgive me, I'm just re-reviewing that myself for the
Yes.
to understand the relevance myself. Yes, I'm grateful to Mr. Lewis, but if one looks at section C on page 121, you will see that Mr. Justice Knowles is identifying the finality point, the very finality point.
Yes.
That your Lordship has.
Where do we find that in the judgment? He 121C is referring to the argument that Miss Bingham was putting this morning.
Well, what he's acknowledging at C is that it is one may look at the position in relation to one defendant, in relation to Fareed, as being final in a sense, and that I think is the position, is the point that your lordship is making to me, that there was finality at a point in time. He accepts that. He understands that. He's identified that. My lord, the fact that he doesn't then refer to it is, again, it would be unfair to infer from that he hadn't taken it into account, particularly as this was a point that he himself alighted on. It wasn't an argument that I put before him that he may have maybe said to have overlooked. It is his own point on finality. So the judgment has to be read in context, in the context of the written and oral arguments that were put in front of him. He expressly records in paragraph 13 that he's taken all of that into account. Of course he's taken the finality point into account. It's his own point. We see it here in this part of the transcript. But I do want to come back on finality just to make one brief additional argument, that Denton Stage 3 requires, at the very least, that the judge take into account not just finality at some historic point in time, but the fact that that issue had moved, the circumstances had moved, things had changed, so that the position that he was dealing with at the hearing was not one of finality. And that must override in the evaluation exercise at Stage 3, how he approaches the finality point, the reality of the position as it existed before him, rather than the fact that it had existed at a particular point in time and changed. That was not an incorrect approach, which is the only question for your lordships.
At the time he determined the set-aside application, he hadn't determined the jurisdiction dispute.
Correct. He determined the jurisdiction point at the very end. That was the logical. He had to. I don't think he could have done it any other way. My lord, your lordships have looked at Hussain and Blakemore. I don't want to take up too much time. I think the relevant points were drawn out in the morning. What I do say is that in both cases, the Court of Appeal clearly considered that the fact that a claim was going to proceed against a co-defendant was a significant factor. Here I have to correct the way in which our case was summarised to your lordships this morning. It may just be a misunderstanding. It has never been our position that the principles to be drawn from Hussain and Blakemore or otherwise is that the fact that a claim against a co-defendant is to proceed is a panacea, that it is an answer in itself without considering other factors. That is not our position. It has never been our position. It is a factor to be weighed alongside all the other relevant factors at Stage 3. That is our argument. We do say that where there is no disruption of the proceedings against the co-defendant and no other prejudice that the claimant can point to from arising from setting aside the judgment, the fact that an identical claim is going to proceed against a co-defendant is a significant Stage 3 factor. That is our argument. That is our legal proposition that we are putting. And you've looked at Blakemore's and Hussain on this. Just to emphasize the point, the co-defendant principle is also recognized in the White Book. turn up the reference for you. Tab 32, page 615, and this is paragraph 3.9.21 of the Red Book. So if you look at the middle of the page, it's 615. Says there are circumstances which favour of the grant of relief from sanctions arise where the defaulting party is a defendant wishing to raise defences or counterclaims which his co-defendants will raise, whether or not he's allowed relief from sanctions. See, for example, Blakemore's. So in case it's being suggested that neither of these cases identify ongoing proceedings against a co-defendant as a relevant factor, we say you get that not just from Blakemore's and Hussein, but you get that also endorsed in the White Book by the learned editors of the White Book. And the justice of that approach is, in my submission, obvious. In circumstances where there's not going to be a disruption of the claim against the co-defendant, in circumstances where the claimant resisting an application to set aside is unable to identify prejudice from setting aside, we're then left with this possibility, this position, a claim against the co-defendant being unsuccessful, thanks to the co-defendant succeeds, and yet a very substantial judgment, here 47 million, having been entered against Fareed for reasons that will be demonstrated in due course to be lacking in merit. That is unjust.
Would you say that of any default judgment, of any size?
This applies in the context of an identical claim proceeding against a co-defendant. It's in that category that the injustice arises, not in a single defendant case. It was a point that the judge was patently entitled to take into account. He did. That was his evaluation. There was nothing obviously wrong about it. Lord, can I just quickly go back to the point about whether the claim against the co-defendant is going to succeed? What is the evidence that you have in this case that it is not going to proceed? There were three hypothetical scenarios given to you. I don't think they were given to Mr. Justice Knowles, I should say, as to why a claim would not succeed. Three hypothetical scenarios. One is, to be fair, I think it was hypothetical scenario in an abstract situation. One is a jurisdiction challenge. Doesn't apply in our case. We've been down that road, and it's water under the bridge.
After the judgment.
Yes. I accept.
At the time he gave judgment, there was still an extant jurisdiction challenge.
Yes, but the point is, was he wrong in assuming, or in taking the approach that claim would proceed? The second point is summary judgment. Summary judgment could be obtained by the claimant. It's not suggested that there's any intention to seek summary judgment in this case. Indeed, that will be hopeless because there's plainly a real prospect of success, including because part of the claim involves an oral agreement. You can't deal with that unless in extreme circumstances on a summary judgment basis. And then the other point was discontinuance. That was the third scenario that was put before you. Discontinuance of by the claimant of the claim against against Michelle. Against Michelle. But it's not suggested that that's at all on the radar. So your lordship has to consider the reality of the case before you in terms of whether it's going to go ahead. And none of the three scenarios put before you by Leadingway as to why it might not actually applies in this case. My lord, I think just for sake of completeness, I ought to touch on ground 2C, which is that the contention that the judge ought to have refused to set aside the application, having found, or once he had reached the point of finding that there was a serious breach for which there was no good reason and no mitigation of any real weight. That's obviously wrong because it entirely ignores the requirement of stage 3. You get to stage 3 where there is a serious breach and where there is no good reason for that breach. Usually you wouldn't even need to go to stage 3 if one of those factors didn't exist. And then as far as mitigation is concerned, the judge took all of the relevant factors into account at stage 3, but it was overridden by the reality of the case against Michelle, proceeding to no detrimental effect of Leadingway. So the approach that Leadingway asserts the judge should have taken in ground 2C is simply wrong in law. Now, ground 2D is the related argument. I think we've actually addressed this, that the judge was wrong to take into account lack of finality as a relevant factor or attributed excessive weight to it. And in this regard, Leadingway, at least in its skeleton argument, claims not to understand what the judge meant by finality, but for reasons we thrashed out already, it's perfectly clear what he was talking about. It's set out expressly in paragraph 11. My lord, then we come to ground 2E, but that's really a compendium of all the previous complaints, and I think I've addressed them. The importance of compliance was the first. Fareed's presumed awareness of the need to comply with the rules. That's an unreal argument because it's based, just very briefly, on the suggestion that the judge below should have inferred from Fareed's involvement in other litigation that he was au fait with the nuances of English procedure and default judgments and the like. And as he says in his evidence, yes, he's involved in lots of litigations, but he hires lawyers to advise him on the niceties of that. The next point is evidence of his finances, that he failed to give evidence of his finances. I think I've dealt with this because this is the double jeopardy issue. The judge took that into account, took into account the fact that all the evidence before him did not amount to good reason for the delay. It was substantial, and there was what else is therefore the relevance of his finances? We move straight on to stage 3, which is what he did. And then finally, the final sub-point under ground 2E is that it said that the judge's only justification for granting relief was the benefit of having an arguable case determined at trial, when it was clearly not just that. It was the fact that an identical case would also be going to trial. My Lord, again, stepping back, the judge's position was this. There was a default judgment in a very substantial sum of 47 million. The claim against Fareed was identical to the claim against Michelle. Leadingway had not identified any prejudice that it would suffer by the default judgment being set aside. There was no wasted costs, there was no delay in allowing it to proceed alongside the claim against Michelle. There was a realistic prospect of defense. In those circumstances, his evaluation was the overall justice of the case merited granting relief. There is nothing flawed in that approach. Even if others might have taken a different approach on discretion, there is nothing fundamentally flawed in the way that Mr. Justice Knowles approached the issue. Therefore, there is no basis for interfering with his judgment and overturning it.
Can I just ask one thing? If D1 had made an application to set aside, which came to determination, let's say, mid-August 2023, so it was over a year after the result, we accept that there would have been absolutely no basis upon which that application could have been granted.
Is your lordship's point that at that stage there wasn't a claim against Fareed that was proceeding? Let me just pause before I agree with that too quickly. Yes, I think that would have to follow.
So after a year, your client couldn't apply to set aside, but somehow his right to set aside a judgment revived over a year after it was entered into, because the claimant chose to serve the second petition.
Except I've take out the word somehow, because it wasn't somehow. It was because, it was very specifically because the claimant had chosen to pursue a claim against Fareed, and that claim was live.
Against Michelle.
Against Michelle, yes. Yes.
Thank you.
May I just check if there's
Yes, of course.
anything I should be addressing? Just one point of background, my lord. I'm not sure, it may be relevant, but looking at the transcript, I think we are again back in supplemental bundle, tab 14, page 106. Just by reference, what we see in sections A to D is a discussion about the correct order in which the applications should be addressed. And following that discussion, it was agreed at the outset of the hearing that jurisdiction would go last. Can I just make this point? It's a forensic one. we can just go back to, I think it's, yes. The actual judgment on the jurisdiction application. Small point, but worth bearing in mind. Page 90, tab 12, page 91. Mr. Justice Knowles identifies in paragraphs 1 to 7 why the jurisdiction application is dismissed. And he concludes by saying, so as a result of all the engagement today, there will be a trial with everyone involved, but it will be here. There is something in that for everyone.
Yes.
So I make that point because it's not difficult to understand what was going on in the judge's mind. He was trying to be fair to both parties in the round,
Yes.
in terms of the way he was approaching things. I think I would have won on the jurisdiction application. Of course, I would say that if it was dealt with in isolation. But it addresses Lord Justice Phillips' point that one should somehow distinguish between the jurisdiction application and the other applications that preceded it on the day, as a point to be taken against. It's not the way it worked.
Thank you very much.
I'm very grateful. Thank you.
Ms. Binger.
Lord, is there one or two points in particular that your lordships would like me to address you on?
There's no need to repeat anything.
No, of course.
If there's anything that Mr. De Cruz raised which you feel you haven't dealt with, then do.
Well, can I ask you,
Yes.
the point which certainly I think has interested some members of the court is the fact that this was a consent order stroke agreement which the judge may or may not have taken into account to a relevant extent. But it's been put by Mr. De Cruz that wasn't the way it was put to the judge below. And also, I wonder if it is really contained in your grounds of appeal.
Yes, my lord. Can I address you on that then? It was, and I didn't want to put this too high, it was squarely put to the court that the court was dealing with a negotiated agreement. And can I show you that in my skeleton below, my lord? Supplemental bundle, page 57. Supplemental bundle, page 57. And it's paragraph 19, where I'm still running through what's happened. So I go through at paragraph 19 here the various requests for extensions and the responses, and I say when a yet further request arrived, series that the claimant reasonably refused the unconditional consent that was requested. However, the claimant's patience not yet exhausted. When they filed a formal application for a third extension, the claimant volunteered a compromise. It would not oppose an extension if the second defendant would submit to peremptory terms, and specifically, the claimant proposed that failing the filing of a challenge within 21 days, the second defendant be debarred from challenging jurisdiction and from defending the claim. The second defendant consented to those terms it is to be inferred with the benefit of advice from signature law. Now, my lords, did I develop an argument around estoppel or suggest to the court that the second defendant was estopped from disputing the proportionality of the agreed sanction? No. Did I remind the court of the limited circumstances in which this court will generally interfere with bargains freely concluded? Did I remind him that, you know, we didn't come within duress, incapacity, mistake or fraud? No. Did I draw the court's attention to any authority for the proposition that the court cannot in these circumstances or should ordinarily not go behind the parties' negotiated peremptory bargain? No, my lord, because we're not aware of any authority. Rather anticipating there might be some at the end of this case. So I don't want to put it too highly. The judge, it was squarely put to the judge that he was dealing with a negotiated agreement, and the short point is that he nowhere weighed either the unless factor or the consent factor in the balance, at least expressly in his judgment. And as to the ground of appeal, my lord, just have a look. The ground of appeal. Which I've managed to lose.
Got my copy.
Failed to take into account, so it's 3A. Failed to take into account that the proportionality wasn't an issue. Yes, the sanction had been considered by the court and recognised by the parties as appropriate insofar as the peremptory terms had been agreed between them. My lord, I say it covers it. Could it be better? It could always be better. But the point that's being got at and the substance of that point of appeal is that there's a failure to recognise the impact of the agreement of peremptory terms. And I say, as I say, the wording may not be perfect, but that's the guts of it, and it's there.
There in paragraph
3A, my
nine.
lord.
Yes, but in what was put to the judge, you've shown us.
Yes, I've shown you the skeleton.
Skeleton argument,
Yes.
page 57, paragraph 19.
Yes. Just that what was before him and what was shown to be before him was an agreed peremptory order, and I don't,
Yeah.
I can't put it higher than that.
No. We've got nothing else that we would like to
No.
throw to you, but if you'd like to
No,
take
my lord,
instructions
I'll
as
leave
to
it there.
right. Thank you all very much. We will reserve judgment. We'll send out a draft, as counsel very well know, but I'm still required to say it in every case. 2 points about sending out a draft. One is that it's not for re-argument of the case, it's to ask the parties to point out obvious factual errors and typos and the like. And the second point is that the draft is confidential to the parties, that is the lay clients and their legal advisors, and is not to be disseminated to anybody else, save with the permission of the court, until the judgment is formally handed down and placed on the National Archive. any ancillary matters should be dealt with by written submissions. We hope that it will be possible to agree the terms of an order in the light of our draft judgment. If not, then written submissions, please, on any points in issue, including but not limited to costs. Thank you very much.